have a question, that would be fantastic, and we'll make sure to call on you. When you are called on, please say your name and outlet. That would be fantastic as well. And one note, that we will be having Jamel Davis speak in the program for Black Voters Matter, but in the Q&A portion, Cliff Albright will be answering questions for Black Voters Matter. So with that, I'm going to get things started, and we're going to kick it off with turning this over to Jasmine Bennie Clark, who many of you know as the founder of Equal Ground. And I'm going to turn it over to her to get things, kick it off as our first plaintiff to speak.
Perfect, thank you, and good morning. My name is Jasmine Bennie Clark. I am the founder and consulting director of Equal Ground Education Fund and Action Fund. I'm also a resident of Florida's Congressional District 10. Equal Ground is a Black-led, community-centered organization working to protect the voting rights of Black Floridians across the state of Florida. We do this through voter registration, voter education, and mobilization. Over the course of the last few years, Governor DeSantis has worked with Republican leadership in the legislature to pass laws that have eroded our voting rights with the passage of laws such as Senate Bill 90 and Senate Bill 524, which make it harder for Floridians to vote, particularly Black and Brown residents. He's also passed laws that attack our free speech by criminalizing protests and limiting conversations about race, privilege, and oppression in businesses and classrooms across the state. He set a dangerous precedent of how government should be ran and allow one branch of government to encroach on the rights of constitutional authority of another. He's also dismantled the Black representation in Congress by reducing the number of Black access seats by 50% from 4 to 2, while simultaneously drawing political maps that disproportionately favor the Republican Party in violation of state and federal laws. This attack on democracy and on Black representation is driven by his political ambition. It is transparent, and it's an attempt to gain favor with the Republican National Party bosses who want to pick more Republican seats in Congress without regard for fairness. But no matter what we look like, what party we belong to, or where we come from, every Floridian deserves to have fair voice, and they deserve to have it heard. And that starts with fair and equal representation. Leading up to Florida's special session on redistricting, we called, texted, and sent over 200,000 emails to the Florida legislature, asking them to remember the oath of office that they took when they chose to legislate. And their decision to move forward with maps that violate our fair district amendments are what led us here today, and that is litigation. We, along with our co-plaintiffs, have been taking the lead and fighting back on the blatant attacks in the Black community, as well as attacks on Black congressional representation. We can't allow this governor or this legislature to destroy our representation in Congress because it does not serve his political interests. Our hope is that in the judicial system, that they will prioritize the choice of voters to have fair districts. And although our courts may look different since the last redistricting process in this state, our Constitution has remained the same. We hope that this litigating team will go into this process over the next day or so with keeping this in mind as we work to keep at least Congressional District 5 intact during this 2022 election season. Thank you so much for your time today, and I do look forward to answering any of your questions.
Thank you very much, Jasmine. And with that, I'm going to turn it over to Monique Holder, who is the Senior Director of Advocacy and Programs for Florida Rising. Thank you, Monique. We'll turn it over to you.
Thank you, and good morning, everyone. Once again, my name is Monique Holder, and I'm the Senior Director of Advocacy and Programs at Florida Rising. Florida Rising is an independent political organization bringing together Black and Brown communities to seize power and govern to advance social, economic, and racial justice across Florida. We are here because the state legislature disregarded its duty of ensuring checks and balances and opted to hand Governor DeSantis a blank check to remake the state however he chooses. We will not stand for that. Through our advocacy efforts, we uplifted the voices of directly impacted voters in opposition of the governor's maps, and their voices were ignored. The practice of drawing districts to favor one political party or racial group skews election results, hurts communities of color by restricting our access to resources, and blocks the will of the voters. No matter who you are or what you look like, voters should pick their leaders, not the other way around. For far too long, Black voting power has been tampered with from every angle. Governor DeSantis's congressional districting plan deeply diminishes Black representation and will have a harmful impact on Black communities far beyond this cycle. We believe the courts have a duty to make this right. The governor himself has acknowledged that his redistricting maps do not comply with the Florida Supreme Court's 2015 ruling about fair districts. With this lawsuit, Florida Rising and our partners hope to ensure that no person is above the law and that every Floridian, no matter where they come from or what they look like, has their voice heard. Thank you.
Thank you very much, Monet. We are going to now hear from Jamel Davis, the Florida State Organizing Manager for Black Voters Jamel, we're going to turn it over to you.
Good morning. My name is Jamel Davis. I am the Florida State Organizing Manager for Black Voters Matter. Black Voters Matter goal is to increase power in marginalized, predominantly Black communities. Effective voting allows a community to determine its own destiny. So Black Voters Matter is involved as a co-plaintiff in this lawsuit because Black Voters Matter, as highlighted in our name. In anticipation that Southern state legislators would ignore relevant census data and unconstitutionally gerrymandered Black and Brown congressional and state districts, Black Voters Matter, in collaboration with Equal Ground and our local partners, built a campaign that allowed Black people to draw maps which sustained or increased Black political representation in the state of Florida. Black Floridians shared these maps with their state representatives. Despite those efforts, the voices of the people were ignored as Governor Ron DeSantis submitted his own racially gerrymandered maps for consideration to the Florida State Legislature, an act never made by a governor in this state's history. This map is a clear violation of the Fair Districts Amendment within Florida's Constitution, an amendment that the people of Florida voted for in 2010. In addition to his state efforts, DeSantis's map also violates the Federal Voting Rights Act, as it dilutes the voting power of Black voters by reducing congressional districts where Black voters had a say in their representation from 4 to only 2. We know that those within the Florida State Legislature who align with Governor DeSantis's values, as well as our governor himself, are not concerned with the equitable and proper representation of Black voters in the state of Florida. But Black Floridians deserve better. We deserve to live in a state in our full, authentic nature, receiving equitable representation and resources while enjoying our God-given freedoms. That is why we are proud to be involved in such a historic and important piece of litigation for not just our state, but our nation as well. That is why we will also continue to work alongside a diverse coalition to remove those representatives who do not desire to share power and resources with all residents of the state of Florida. Thank you.
Thank you very much, Jamil. And right now we're going to pause from hearing from plaintiffs. We'll be back to hearing from one more plaintiff in a moment, but I'm going to turn it now to our legal counsel here, Olivia Mendoza, to talk to us and you all about the filing that will be heard tomorrow, the preliminary injunction and the broader matters of the case. So with that, I'll turn it over to Olivia Mendoza, with the Deputy Director of Litigation and Policy at the National Redistricting Foundation and our counsel on this case. Thank you, Olivia.
Good morning, and thank you so much. I'm with the National Redistricting Foundation, and we are pleased to be supporting all of the individual voter plaintiffs that are part of this case, as well as these community-based organizations that we've had the pleasure to hear from this morning, and we'll hear from after I finish providing just a quick overview of what the claims are and also the hearing that is scheduled for tomorrow. So in summary, there are 5 claims, 5 legal claims that the organizational plaintiffs and the voter plaintiffs have brought forward under the state constitution, under the Florida Fair Districts Amendments. In essence, there are 3 tier 1 claims alleging that the map passed by the legislature that DeSantis advocated for essentially violates the Fair Districts Amendments by under the retrogression, the non-retrogression standard, and also intentional diminishment of Black voters and their ability to elect, as well as intentional partisan gerrymandering. And then there are an additional 2 claims, tier 2 claims, non-compactness and unnecessary splits that are included in this map in violation of the Fair Districts Amendments. As to tomorrow's preliminary injunction hearing, the hearing is on a very narrow issue, and that is that we are seeking relief for the way that the Congressional District 5 was diminished in the past map, the DeSantis map. So we are seeking a preliminary injunction for relief here in 2022. Now, we still have all 5 claims that we will be advancing throughout the litigation process, but we are asking the court to provide immediate relief for this election on CD5 under the diminishment standard or the retrogression, because that CD, that congressional district, was an ability to elect district for Black Floridians in North Florida. And by the admission of the legislature themselves, that is no longer the case. And that is really the summary of the claims we're bringing and the hearing, the narrow issue that the court will hear tomorrow on the preliminary injunction.
Great. Thank you so much, Olivia, for that. And our final speaker before we open it up to questions is going to be Sean Bartlett, the second vice president of the League of Women Voters of Florida. So Sean, I'll turn it over to you.
The League of Women Voters of Florida is a nonpartisan political organization. Nonpartisan political organization encouraging informed and active participation in government, working to increase understanding of major policy issues and advocating for legislative changes and policies for the public good. We work to empower voters and defend democracy. Sadly, this is not the first fight over fair maps in Florida. Historically, Florida's been one of the most gerrymandered states in the country. The League's been working on resolution of that for over 80 years. In 2008, 2 citizen initiatives were created, one specifically for congressional districts. Both passed in 2010 by 63% approval of the voters. The governor and the legislature began fighting those amendments immediately from day one. The legislature ignored the amendments and drew maps that weren't even close to meeting the Fair Districts criteria. In 2014, we took the congressional map to the Circuit Court in Tallahassee with Judge Lewis presiding. Let the Carl Hiaasen novel begin. There were secret meetings, emails, texts, vacations together, and more to undermine the Fair Districts process. The judge ordered new maps be drawn, same timing kind of as today, heading into a primary election. The redrawn maps were accepted. We did not find the new map compliant and appealed to the state Supreme Court. They ruled in our favor on all accounts, ultimately rejecting the maps put forward by the legislature and giving final approval to the map drawn by the League and Common Cause just in time for the 2016 elections. And now it just feels like Groundhog Day. Here we are all over again. After an attempt by the legislature to comply with fair districts, the maps were vetoed, the legislature caved. Their actions are not only an attack on African-American voters, but an attack on the legitimacy of the government in general, because the governor is advocating for a map that he knows violates Florida law today. But historically, this feels even worse. Never has a governor in Florida vetoed maps, and these maps were created by his own party. If every government official took actions that violated the law because they wanted the law to be changed in the future, that would create total chaos and anarchy. The map is a threat to the rule of law in Florida. We find no solace in returning to court a decade later to fight again for fair districts that the voters in Florida demanded, and to ensure that the law is followed in the Sunshine State.
Thank you so much, Sean. And thank you to all of our speakers this morning, from the fellow litigants and Olivia on the legal team. With that, I am going to open it up to Q&A. We have one question already. If you have a question, just note it in your Q&A function, or raise your hand. I see some folks have done that as well, and we will call on everyone and get to everyone here, and I'll allow everyone. You don't need to write out your question. I'm going to allow you to talk. So with that, we're going to start with Jacob Ogles. Jacob, if you could announce who you are with, along with if your question is directed to anyone specifically, that would be great. So I'll turn it over to you, Jacob.
Okay, can you hear me?
We hear you.
Okay. Jacob Ogles from Florida Politics here. I know election officials in the federal lawsuit had said they need a map in place by May 13th, this Friday. Do you think that a case has been made to justify courts stepping in by that point or ahead of the 2022 midterms to put your injunction in place and put this proposed alternative map in place? And what is the likelihood, based on cases around the country, that courts will issue an injunction that could impact the 2022 election cycle?
Olivia, does that sounds best for you?
Yeah, happy to take that question. Thank you, Jacob. Lynn, I'm going to try to make sure that I captured all your questions, but the primary test that the court has here is state by state, right? And election by election. And we do feel that the primary elections in Florida are 4 months away. And so there is sufficient time for the court to implement, to essentially grant the PI and enjoin the use of this map as to the narrow question of the retrogression claim in CD5, and be able to find a ability to a map that will actually serve North Floridians in the manner that is constitutional. And so we wouldn't have, we were very thoughtful about what is realistic and what relief can we provide in 2022, and feel confident that this narrow issue can and should be decided prior to the election. As to your question about the likelihood, it's really difficult to say. I think that you are referencing potentially the Alabama decision that came about a couple of months ago, but this is a different set of facts, a different claim that is being brought here before the court. And so I really do think that taking the facts and what is before us, that there is sufficient time to provide this remedy.
Do you think that the May 13th date is a hard line in your eyes, or do you think that the courts could take more time than that and still impact the November elections?
So the May 13th date is a date being considered in the federal case. And so our case is in state court. So it's difficult for me to answer specifically to that date because I just don't have that, all of the expert reports and the witness testimony and such that's been happening in that federal case.
Thank you, Olivia. We're going to move now to Aaron Navarro.
Hi, can you hear me?
We got you, Aaron.
Awesome. Thank you all for taking the time. Olivia, you kind of addressed this a little bit, but when it comes to this case in state court, can you just lay out the expected timeline that we should be following for this case in state court?
And just before you do that, Olivia, just say Aaron is with CBS News.
Yes, sorry.
Of course, Aaron, I'm happy to do so. So the organizational plaintiffs that are here with you today are presenting, the case will be presented tomorrow in the PI hearing, the preliminary injunction hearing, again, on the narrow question as to relief for CD5. Typically, the court will address, rule on the PI within 7 to 14 days. It's hard after the presentation of the evidence, the court will let us know when the ruling will come down, but it should be fairly quickly. We have asked for an expedited ruling, of course. And then depending on that ruling, either if they vote in favor of the injunction and granting the injunction, then the court can implement the remedy, right? Maybe potentially sending it back to the legislature or adopting one of the maps that have been submitted to be considered for the remedial phase. The other option is that the state could file an appeal, and then we can see that move its way through the judicial system in Florida. As to the other claims, those are on a longer time frame because they are very evidence intensive. And so we likely will continue to move those claims forward through the 2022-23, trying to seek relief for 2024.
Gotcha. And sorry, Andrew, can I?
Oh, you can have a follow-up for sure.
Cool. On a kind of different lens, we saw the Department of Justice get involved when it comes to racial gerrymandering in Texas. Do any of you have a sense on if that could happen here in Florida? Just curious.
I don't think we have not received any kind of signal that that is something to be anticipated, and the Texas posture was a little different because it's a federal, it's in a federal court. So I think that is something that we'll have to wait and see.
Got it. Thank you.
Thank you. And just a reminder, when I unmute you, just to say which outlet you're with, and if your question is directed to anyone specifically. Just building off of Aaron's question, I want to turn it over to Gary Fineout, who has a follow-up.
Yeah, hi. I put it in the chat, but I just wanted to make clear that I understood I haven't gone through all the filings, but you're asking for a preliminary injunction, but you have not advocated a specific remedy. And I'm curious about that because the challenge here, of course, is that Florida's going from 27 to 28 seats. So you can't use the existing map with the existing CD5. You have to have a different map in place. So did I get that right, that you all would either advocate maybe one of the other maps that were maybe approved by the Senate or what have you, or even ask the legislature to? I just want to make sure you at this point in time do not have a specific remedy you are advocating.
Gary, that is correct in that we are not advocating for the previous map, the map from 2011, to be implemented if this preliminary injunction is granted. We have provided in the case, different options that show the maps that could be considered, but ultimately the court will decide the remedial phase. It could be maps submitted by the legislature potentially, or the judge, the court could send it back to the legislature to redraw.
Great, thanks, Olivia. We're going to move now to Forrest Saunders with Scribs TV. Let me unmute you here, Forrest.
Hey there, can you hear me?
We got you.
Excellent. Yeah, basically asking similar question to what Gary just had mentioned. You know, what is the remedy that you guys are specifically seeking? And I think you just addressed it there, but if anybody wants to elaborate on it, that's exactly what I'm curious about, is with this preliminary injunction, what would be the remedy that would be preferable? Obviously, some preservation of Congressional District 5, but is there a specific remedy that you're looking for?
Well, the claim alleges that essentially this map, the DeSantis map, what it has done is completely made it an impossibility for Black voters in North Florida to be able to elect their candidate of choice. And that is unconstitutional under the Fair Districts Amendment. So the remedy that we would seek is the ability to give that to a district that gives that ability back to Floridians. Like, what we should not lose sight of is the individuals being impacted are real voters. These are individuals who for the past 10 years have been able to, or at least since the map was adjudicated after the last litigation, I think in 2012, have had their vote counted. And we cannot lose sight that that is what we are trying to address here.
Yeah, if I could, Cliff Albright, co-founder and executive director of Black Voters Matter, if I could just co-sign on with what Olivia is saying, I don't think it should be lost or inferred that, because we are not proposing a specific remedy, that therefore there is no reasonable and quick remedy that can be imposed. There's any number of maps, some, as you heard Jamel Davis referred to, some that community members actually played a part in helping to design, that could be considered and passed in a timely manner. And so there are options out there. We don't want it to be lost, as Olivia said, that these are real voters, that the main issue, the main purpose of the injunction is that for whatever other options are out there, what we know is that these maps that the governor has proposed are simply not constitutional, and that therefore we need this injunction, and then we can work out what other maps might be able to be accepted. But there are several versions of maps that would at least come closer to granting the political voice that Black voters and other voters within the state deserve to have.
Thank you, Cliff. Any of the other plaintiffs have additions there before we move on to the next question? Great.
I would just add, and obviously co-sign to what Cliff stated. The state has a state database that for the first time in its history created a website that allowed everyday citizens to submit maps to the Florida legislature for those maps to be reviewed as an option for getting a fair map passed that met our Fair Districts Amendments 5 and 6. So our state has a database of thousands of options that are available to them. It is up to them and their constitutional duty to draw and or obtain a map that is necessary for us to move forward with. They did attempt to do so and then pulled back when the governor decided to threaten their budget and their bill items. And so it is not that they are not able to create a map. It is not our job to do that. It is their constitutional job to do that. And citizens have created options for them that they need to go back to the table and consider and propose as options for our court to also consider if this issue can't be resolved timely.
Thanks, Jasmine. I want to move forward here because we still have a bunch of questions at WTSP in Tampa.
Can you hear me all right?
I think we can, Eric.
Great. My question is that the legislature, the governor.
Eric, let me pause you for a second. You're a little soft, so a little more volume would be great.
Any better?
Yeah.
The legislature and the governor specifically put into this that the case to be heard in Leon County. You explain to folks out there why you think they did that and whether or not that may impact the case.
Sorry, Eric, you may have to type that question into the chat. We cannot hear, unfortunately.
Yeah. All
While
right,
he's
Eric,
doing that.
if you can type your question into the chat, that would be fantastic. In the meantime, we're going to jump to Mary Ellen Class with the Miami Herald.
Thank you. I just wanted to return to the question about the timing here. Some supervisors of elections have said that we need a May 13th deadline. Others have continued to look at the June deadline. And I wondered if there is, if you could point to the precedent in Florida for delaying a primary or qualifying because of redistricting. Can you talk about that at all?
Mary Ellen, I don't know if I can point to a specific precedent that is in a very similar situation, but I think that what I can point to is the risk here is an administrative deadline moving forward under a constitutional violation. And so, really balancing and asking the court to consider that the remedy we are asking for 2022 is a narrow remedy around CD5, and the risk of holding an administrative deadline is that truly it could potentially be a constitutional violation of voters' rights. And so really trying to balance the interest. I'm not minimizing how difficult it is to administer and run elections, but I'll just say again that we're only in this situation because the governor called back a special session and made sure that a map was passed that by the own legislators' admission creates a retrogression standard in CD5.
Thanks, Olivia. I want to go back to Eric Glaser here in Tampa. His question specifically as it relates to Leon County is that the governor and legislature specifically called for this case to be heard in Leon County. Please explain what you think they were attempting to do and whether it might impact the outcome of the case. Olivia, I think that probably falls to you as well.
Well, I won't attempt to get in the minds of why they were trying to move it into Leon County, but I will say that there is case law in Florida that allows for this concept called home venue privilege, which allows the government the ability to bring claims in their home venue, which in this instance is Leon County. And so that is ultimately why we filed there, because we really do want to get to the substantive issues as quickly as possible and not end up in a fight over venue.
Thank you, Olivia. I'm going to move here to Mike LaCura with the Florida Channel, who has a question.
Yes, thank you. Going back to remedy would you accept the secondary map that was the legislature originally passed that the governor vetoed, but there was a secondary map that kind of preserved CD5 basically? Is that something that you would want, or is there a specific map that the legislature has put together throughout the process that you would want the court to adopt, or another map that perhaps was submitted on the Florida Redistricting.gov website over the previous months?
In our filings, we have pointed to the Senate map that was passed as one of the options for the court to consider. And all other remedial maps, I think we'll assess them. Once the court finds and grants the injunction, then we'll assess the options of the remedial maps that are being considered.
Okay. Thank you. And I was curious as well if there's a specific date that you feel like there needs to be a map in place by the court going forward.
I do think that, taking into consideration the position of the administrators, I think it is feasible for us to ask the court to issue a ruling and to implement a map by, potentially even the end of this month.
Okay.
Because as Cliff and I think Jasmine have both noted, we're not in a world where we're trying to create a map from scratch. There are many examples of maps, constitutional maps. We believe there are constitutional maps that were submitted and even voted on and approved through the legislative process.
Okay. And then do you expect to have testimony tomorrow from your side, both sides potentially as part of this?
Yeah, there will be witnesses tomorrow, primarily expert witnesses. Again, the burden that we have in a preliminary injunction hearing is to be able to prove that we would likely win on the merits, and that that the remedy merits the injury being caused. That you can't wait until a trial in 2023 to get a remedy because the injury would have impact in 2022. So there will be experts from both sides, from the organizational and individual plaintiffs, as well as from the state.
Thanks, Mike, for that question. I want to get to John Kennedy now with Gannett, Florida. So turning it over to him.
Thank you. Yeah, I was really just looking to the arguments tomorrow, thinking you seem to be suggesting that the bulk of the arguments will focus on CD5. And the other areas of the state, though, that I know you do have issues with, such as CD10 in the Orlando area, or the other districts that fold around Tampa Bay, those also are being contested. But tomorrow, it seems that you are largely, and correct me if I'm wrong, you are largely going to make your case for a preliminary injunction based on what you see as the wrongs done in CD5. Is that correct?
That's correct. That is correct. So the relief we're seeking in this preliminary injunction is specific as to the injury in North Florida, right? What has happened to the Congressional District 5 and under the retrogression standard under fair districts. Now that is specifically for a preliminary injunction. We have 5 total claims that 3 are tier 1 claims under fair districts amendment, so the retrogression, the intentional vote dilution, and the partisan gerrymandering. And additionally, we have 2 other claims, the non-compactness and unnecessary splitting of political subdivisions. That's the whole case that the plaintiffs here today and the individual plaintiffs are bringing forward. But in the process, that is a trial that will come, what we will seek the full trial on those other claims. But we are asking the court tomorrow to enjoin the existing map as to North Florida, because it is truly a question of math. Before this DeSantis map was passed, Floridians, specifically Black voters in North Florida, had the ability to elect their candidate of choice. And by the legislature's own admission, they are no longer able to do that. And so the question for tomorrow is a narrow one, but that does not preclude the rest of the claims that we will be advancing, throughout the traditional litigation process.
And if I could just follow just a little bit with that, indeed, if you've outlined and mentioned that a trial could be 2023. However, those other areas of the state that you still have disputes with, if there was an attempt by the court or by the legislature to reinsert another map, as a, if you successfully get the preliminary injunction tomorrow, for example, you would probably still be fighting those other districts this year, would you not? Rather than just concede and say, we'll wait until 2023 for the full trial?
Yes, absolutely. We don't have a trial date, so we don't have a scheduling order for the other claims. I would imagine that the trial would be potentially later this summer or early fall. I don't want to suggest that I even have I don't know yet when the court would set that. But I imagine it would be in this year, but we wouldn't be able to get a remedy for the 2022 election. So the trial might happen. It likely will happen this year, but we understand that under those claims wouldn't see the remedy for this election. Does that clarification help?
Yes, yeah, that does help. Thank you.
Thank you, John. And Olivia, one follow-up from Eric Glaser at WTSP 10 News in Tampa. He writes, so if the preliminary injunction is granted, this would or would not impact the changes in Tampa Bay during the 2022 election?
It likely would not impact the Tampa Bay area for this 2022 election.
Thank you. And with that, all the questions on the board have been answered. I want to allow any other questions, one final pass to see if anyone else has questions. It looks like we do have one more question from Renata Di Gregorio from First Coast News in Jacksonville. So we're gonna open it up to her. Renata, I'll turn it over to you for your question. Renata, you should be able to speak now.
Hi, my question actually got answered, so I am good.
Fantastic, thank you. All right, I think that does it. Unless there are, we'll go one more time for questions. Seeing none, I'm going to wrap up the call and just remind everyone that.
Can I?
Cliff, go ahead. Absolutely, thank you.
I just wanted to say one thing, because I know we were getting the recurring question in regards to, the remedy and the timeline. I just really have to express this, that I can't think of any other situation where, because we got to keep in mind, that these deadlines are coming from the elected officials, right, who are representing the state, some county level, whatever, but essentially representing the state. I can't think of any other situation where we allow the person who's being accused of violating the rights to also create the timeline on whether or not our rights can be affirmed, right? I mean, we know that there are statute of limitations for a whole bunch of things, for theft and rape and even murder, but the perpetrator doesn't get to say, you know what, yeah, I violated your rights, but you ran out of time because I really need you to pursue these rights by a certain date, or else you're not going to be able to get it. Yeah, I stole your cell phone, or yeah, I stole your $1,000, but you know what? If you don't do something about it by Friday, you're not going to be able to hold me accountable. In no other situation would we even consider that to be a valid argument. But here we are, where we're being forced or encouraged to fall to the dictates of the timelines that the very elected officials who are doing the denial of the constitutional rights that we're being held account to a timeline that they are setting for themselves. And so I really just want us to rethink the way that we're even framing this situation. And as Olivia and everybody has said, really centering not the deadline that they are imposing, but centering the denial of rights to actual voters, millions of voters all across the state of Florida. If we center in that on the many solutions that have already been offered, then I think we'll be able to get to a situation where folks' rights can be respected. But if we're centering it on the elected officials themselves, then that path will inevitably lead us down a very dark place.
Cliff, thank you for that. Very important points. I just want to one more follow up from Gary Fineout at Politico. Gary, I'll turn it over to you.
Yeah, I did want to try to get someone to answer on the record about one of the things that the supporters of the map keep throwing up is that, well, Representative Donalds was elected in Southwest Florida. Now, obviously, that is a district that has a majority of white voting age population, but they are trying to use Representative Donalds' election as sort of an argument that this is why the courts are moving to a new way of evaluating these districts, and the North Carolina decision, and the idea being race neutral, et cetera, et cetera. I just, is there anyone who could sort of address the situation of Representative Donalds and why his election does or does not undercut the argument?
I think what we can say here, and it's important to not conflate the issues or the courts, right? This claim is in Florida State Court alleging a violation of the Florida State Constitution, an amendment passed overwhelmingly by Florida voters. And specifically for tomorrow, that this map can't move forward. We don't want voters voting under this unconstitutional map as to the retrogression that happened in CD5. And as to Representative Donalds' district down in South Florida, I do think that we will see more of that literally litigated, but more of the expert evidence and the information that will help inform the claims that we will have brought and will continue to advance on the whole map, which is not a retrogression claim down in South Florida.
No, I understand the issue of retrogression and what you're arguing there with CD5. Obviously, that is you're making an argument under fair districts. I was just trying to get to the, excuse me, as reporters, we have to not only deal with the technical matters of which you are dealing with, but we have to ask, we often get responses from others that speak to broader issues. I understand what you're saying. You're saying, look, that's a question as to that broader question as to whether or not those Supreme Court decisions that DeSantis is relying on really back up his assertion that fair districts is somehow in conflict with U.S. Supreme Court rulings. So I understand that. I wanted to put the question out there because that's one of the talking points that is being, put out there.
Yeah, no, Gary, I totally hear you. I hear your question, but the truth of the matter, I guess, the truth is that we don't yet know what the Supreme Court is going to do with federal law, whether it's the Voting Rights Act or other federal, the constitutional protections under the 14th Amendment. And so my answer might be not as satisfying but we are aware, we are carefully monitoring those decisions from the court, but are also focused on the state claims in front of us.
Thank you, Olivia, for that. And Gary, we completely understand your role as a journalist to ask the tough questions. So thank you for doing that as well. So with that, I don't see any additional questions at this time. I want to just open it up for the plaintiffs one more time. Any closing remarks, anything that has been left unsaid that folks want to say before we close this? Great. With that, I'm going to let everyone get out of here. I just want to let everyone on the line know we will be sending around a recording of this call, and all of you know our emails at this point, but if you email team@feldmanstrategies.com, you can follow up with any questions. We can also set up individual interviews and so forth. So I appreciate everyone joining, and you'll be hearing from us very shortly. The hearing tomorrow starts at 9 a.m. Thank you very much.